Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey, y'all, so this is an update. Well, not really an update, more like an explanation on the Corey Pritchett and Carmen divorce. So let's hop right into this. So I totally forgot to explain to you guys as far as the different routes that this divorce case can take. If you are not familiar with what's going on, Carmen filed a divorce against Corey. So she is the petitioner, he is the respondent. I explained in the last video that the divorce that Corey was supposedly holding up in front of that ICE sign. He stated that he filed that divorce in Alabama back in August or September. However, if anything was to be concluded from that, it's probably that it's dismissed. And the reason why I'm saying that is a number of things. I know here in the state of Texas that in order for you to file a divorce in the state, in the county that you live in, one, you have to be a resident of that county for at least 60 days. You have to be in the state of Texas for at least 6 months. So, by him being in Texas since I want to say 2022, there's no possible way that he would have filed suit for now. He can file suit in the state of Alabama. However, it likely will not go far. Now, if he filed it, I have no idea. If he went to a computer lab and printed out the documents, I don't know. I have never seen a petition that looks like that because I don't care what state I am pulling files from, what he held up, I have no clue as to what that is or where he found that form. Um, Going on to say that divorce is not valid, even if it was, even if he did file it as a pro se client or a self-representative client, it didn't get far past him even trying to get her served, because I don't even know if he attempted to serve her through a process server or himself. Either way, that Alabama divorce is null and void. Okay. Now, shortly after he was released from Harris County Sheriff's Office in regards to the two aggravated kidnapping charges, Carmen filed for a divorce in Fort Bend County. Now, there are two things that are going to take place here. Two ways. One, you file a petition in the state of Texas, and that's anywhere. You have to serve the client or the respondent or the defendant. Okay. Now, if she believes that they can work something out as to where she does not have to serve him by a constable or a sheriff or a process server. She can say, hey, I filed for divorce. Here are the papers. If you want to sign a waiver of service, waiving your, not your rights, but waiving to be served by a process server or a constable, then we could do it this way. Once you get that waiver of service back to me, notarized, and sign the final divorce decree, then we could just go ahead and file. In the state of Texas, it is mandatory that you wait 60 days. So when you file the petition, you have to wait 60 days. Now, in that time period, let's say that he didn't sign, he says, no, I'm not going to sign that waiver of service. Then she has to go forward with a process server or a constable or sheriff to serve him. That way, it will allow him to respond properly to the lawsuit or the divorce petition. Okay. So the first way is agreeing to sign a waiver of service, get that notarized, and you're just saying, I waive from being served by a process server, a constable, or sheriff, sign the final divorce decree. And when that 60 days is up, they could go ahead and file the remainder of the documents and get rid of not get rid of, proceed with divorce. And usually it takes anywhere from like a week up to 2 weeks for a judge to look at the final divorce decree. decree and say, okay, it's all good. And I'll explain what they have to, put in a divorce decree because they have kids. So that's one way. The second way, if he doesn't agree to sign the waiver of service, then he has to be served by a process server, a constable, or a sheriff. And once he is served, he has 20 days within that time period to respond to the petition for divorce. If he does not respond, then she can enter a default judgment where he doesn't, it doesn't even matter if, he signs or not, because he had an opportunity to respond, but he didn't. But you have to always ensure that they are served a copy of the petition. You just can't move to a default judgment. They have to be served. All right. So if you didn't answer, she can move to a default judgment and go on about her business. But she still has to wait that mandatory 60 days. All right. Now let's say that he goes ahead, gets served, and he does answer, okay? But he contests everything that she states in the petition. So, meaning he's going to fight back. Then this is probably where both of them are going to need. Well, she already has an attorney. He might need to go ahead and get an attorney. All right. Because it just depends on what's stated in that petition that he does not agree with. Okay. So when it comes for that 60th day, but that's one thing. But if they can't come to any type of agreement, more than likely they might have to go to some type of mediation in order to work out an agreement. Okay. But the other alternative is him filing an answer, but he doesn't contest to anything. And then the 60 days come up, and then she files the final divorce decree that they both agree on. Then that will go before a judge. In about a week or two, they will be divorced. Okay. But in any of those instances, they still have to wait the mandatory 60 days before they can file the final divorce decree for review. Now, because they have kids, there is going to have to be some type of possession order, whether it is a standard possession order where, if you live so many miles apart. Well, she's in Fort Bend, he's in Harris County. I don't know like exactly the distance, but if they just do a regular standard petition standard possession order, then it could be like, okay, he would get the kids every first, third, and fifth Saturday and Sunday of the month, or he might get them every weekend. It just all depends. If it's a customized, they might have to work out some type of agreement. You get the kids one week, I get the kids one week, so on and so forth. Okay. But they have to submit that possession order with their final divorce decree. Another thing that can be discussed is what is it called? Child support. Okay. Now, this man has already told the Harris County Criminal Court that he don't make no money. Okay. The judge is possibly going to take that into consideration. All right. Might just might. But I'm sure that her attorney is going to be like, okay, this dude, he's flashing all this stuff on social media. He looks like well, not looks like he get money. He portrays himself as to having money. Okay. So I'm pretty sure that they're going to dig and they're going to be like, well, here's his finances. This is how much he makes. And they will determine an amount of child support in the event that they don't agree. Like in Texas, 20%. 20% for the first kid. 20% for the first kid. So if they don't come with an agreement of how much he's going to pay for child support, then the judge going to figure it out for him. And that's going to be based off of whatever financial records he can show them of how much he makes. So it's all it could go a number of ways. But I know a lot of people are checking out the docket and trying to see if he got served. Like I said, normally we will see citations. It will say a issuance of citations that's not here, which leads me to believe that they're trying to do the waiver of service first. And if that does not work out, then they will ask the court for a citation so that way they can properly serve Corey. But as of right now, the petition was filed on 130. So on 131, that is when that 60-day started. So the ball is in his court, whether he does the waiver of service or whether she opts to have him serve. He has to get served a copy of that petition in order for her to proceed with the divorce. So I hope that helped. If you guys have any type of questions in regards to this, especially because this is a Texas case and I deal with family law, definitely ask them in the comments below, and I will try my best to get to each and every one of you all's question. But y'all tell me what y'all think about this. I still see Corey on this here internet just faking the funk. I don't know what he trying to believe, and I'm pretty sure if we watching, Harris County Criminal Court is watching, because you done told these people that you didn't have no money, you didn't got this indigency, and you trying to get an investigator for free. You already got this court appointed attorney for free. So bro, what you out here doing? But y'all let me know what y'all think in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and have a blessed night. Bye.